If you are a green card holder living in the United States right now, you need to stop everything you are doing and listen very carefully to what I am about to share with you. There are significant legislative proposals and regulatory changes being discussed in Washington that could fundamentally alter what it means to hold a green card in America starting in 2026. These changes could affect your ability to maintain your permanent resident status, your pathway to citizenship, your access to government benefits, and even your ability to sponsor family members. Many green card holders have no idea these discussions are happening, and by the time they find out, it could be too late to prepare. Now, before we go any further, I want to make something absolutely clear. This video is designed to inform you about proposed changes and policy discussions that are currently happening. Nothing I share today is final law yet, but these proposals are very real and are being actively debated. The smart green card holders are the ones who prepare now rather than waiting until changes are already implemented. Knowledge is power, and today I am giving you the power to understand exactly what could be coming your way. Let us start with the most significant proposed change that has green card holders across the country deeply concerned. There is currently discussion in Congress about implementing what some legislators are calling continuous physical presence requirements for permanent residents. Right now, as a green card holder, you can travel outside the United States for up to 6 months without needing special permission, and you can travel for up to a year with a re-entry permit. But the new proposals being discussed could dramatically shorten these timeframes. Under the proposed framework being debated, green card holders might need to maintain continuous physical presence in the United States for at least 10 months out of every 12-month period. This means if you are someone who regularly travels abroad for extended periods to visit family, conduct business, or care for elderly relatives, you could find yourself at serious risk of losing your permanent resident status. The legislators pushing for these changes argue that permanent residents should actually be living permanently in the United States, not using the green card as a convenient travel document. But here is where things get even more concerning. The proposals include enhanced tracking mechanisms that would monitor entry and exit records much more closely than current systems do. Every time you leave the country and every time you return would be carefully logged and analyzed. If the system detects that you are spending too much time abroad, it could trigger an automatic review of your green card status. This is not science fiction. The technology and infrastructure to do this already exists, and there are active discussions about implementing it as early as 2026. Now let us talk about something that affects nearly every green card holder in America, and that is the pathway to citizenship through naturalization. Currently, to become a naturalized citizen, you need to have been a permanent resident for at least 5 years, or 3 years if you are married to a United States citizen. You need to demonstrate continuous residence, physical presence, and good moral character, but the proposed changes being discussed could make this process significantly more difficult. One proposal that has gained considerable traction would extend the residency requirement from 5 years to 7 years for most green card holders. That means an additional 2 years of waiting before you can even apply for citizenship. For those married to citizens, the proposal would extend the requirement from 3 years to 5 years. These extended waiting periods would affect millions of green card holders who are currently planning their naturalization timeline. But the waiting period extension is not even the most alarming part. There are discussions about implementing what legislators are calling enhanced civics requirements. Currently, the citizenship test covers basic United States history and government, with 100 possible questions and applicants needing to correctly answer 6 out of 10 questions asked. The proposed changes would expand this test significantly, potentially requiring applicants to demonstrate proficiency in American constitutional law, federal and state government structures, and detailed knowledge of historical events. Additionally, the English language requirements could become much more stringent. Right now, the English requirement is relatively basic, focusing on reading, writing, and speaking ability at a fundamental level. The proposed changes would require applicants to demonstrate English proficiency at what would be considered an intermediate level, including the ability to read and comprehend complex texts and write structured paragraphs. For many green card holders, especially those who arrived in the United States later in life, these enhanced requirements could present a significant barrier to citizenship. Let me now address something that has caused tremendous anxiety in immigrant communities, and that is the discussion around public benefits and green card status. Under current law, using certain public benefits can trigger what is known as a public charge determination, which can affect your ability to maintain or renew your green card. but the proposals being discussed would dramatically expand what counts toward a public charge determination. Currently, the public charge rule primarily considers cash assistance programs like temporary assistance for needy families and supplemental security income. But under the proposed expansions, the list of programs that could count against you would grow substantially. There are discussions about including Medicaid coverage beyond emergency services, supplemental nutrition assistance program benefits, housing assistance programs, and even certain tax credits. If these changes go into effect, green card holders who use any of these programs could find their permanent resident status called into question. Now, I know what many of you are thinking. You might be saying that you paid into these systems through your taxes and you have every right to use them. And you would be absolutely correct in saying that. But the proposed changes do not take that fairness argument into account. The legislators pushing for these rules argue that permanent residents should be self-sufficient and not rely on government assistance. Whether you agree with this philosophy or not is beside the point. What matters is that these discussions are happening and could become law. Here is what makes this particularly concerning. The proposals include a look-back period that would review your entire history of benefit usage since receiving your green card. This means even if you used benefits years ago during a temporary hardship but have been completely self-sufficient since then, that historical usage could still be held against you. Some versions of the proposal suggest a look-back period of up to 10 years. Let us shift our focus to family-based immigration sponsorship because the proposed changes here could affect generations of families. Currently, green card holders can sponsor their spouses and unmarried children for green cards, although the wait times can be substantial. But there are active discussions about restricting the sponsorship abilities of permanent residents even further. One proposal would require green card holders to wait at least 5 years before they can sponsor any family members. Another proposal would require sponsors to demonstrate a higher income threshold than currently required, potentially 150% of the federal poverty guidelines instead of the current 125%. For families with modest incomes, this could make sponsorship financially impossible. But perhaps the most dramatic proposal being discussed would eliminate the ability of green card holders to sponsor adult children entirely. Under this proposal, only United States citizens would be able to sponsor adult children, meaning green card holders would need to wait until they complete the naturalization process before they could begin the sponsorship process for their grown children. Combined with the proposed extended naturalization waiting periods I mentioned earlier, this could add many years to family reunification timelines. Now let us talk about something that does not get enough attention, and that is the proposal to implement regular status reviews for green card holders. Currently, once you have your green card, you renew it every 10 years, and the renewal process is relatively straightforward, assuming you have not committed any disqualifying actions. But the proposed changes would transform this renewal into a comprehensive status review. Under this proposal, every 10-year renewal would involve a thorough examination of your time spent in the United States, your tax compliance history, any criminal record including minor infractions, your use of public benefits, and your overall compliance with immigration law. This would not be a simple renewal where you pay a fee and receive a new card. It would be a full reassessment of whether you still qualify for permanent resident status. The proposals also include discussions about implementing a tiered green card system. Under this system, new green cards would come with conditional status for the first 5 years. During this conditional period, you would be subject to even more stringent requirements and regular check-ins with immigration authorities. Only after successfully completing the conditional period would you receive a traditional permanent green card. This would essentially create a probationary period for new permanent residents. For those of you who obtained your green card through employment, the proposed changes include provisions that could affect you specifically. There are discussions about implementing what is being called occupational continuity requirements. This would require employment-based green card holders to remain in the same occupation or industry for a specified period after receiving their green card. If you change careers or industries too quickly, it could trigger a review of whether your green card was obtained properly. There are also proposals targeting investors who obtained green cards through the EB-5 program. These proposals would require ongoing proof that the investment continues to generate the required number of jobs and that the funds remain invested for extended periods beyond current requirements. Some versions of the proposal would require EB-5 investors to maintain their investments for up to 10 years instead of the current shorter periods. Now, here is something that every green card holder needs to understand. These proposed changes, if implemented, would likely not include generous grandfather clauses. Many of the proposals specifically state that new requirements would apply to all green card holders regardless of when they obtain their status. This means even if you have had your green card for 20 years and have followed every rule perfectly, you could still be subject to these new requirements. Let me tell you what the smart green card holders are doing right now. They are documenting everything. They are keeping meticulous records of their time spent in the United States, their travel history, their employment history, and their tax returns. They are organizing these documents so that if new requirements are implemented, they can quickly demonstrate their compliance. The smart green card holders are also consulting with immigration attorneys now rather than waiting. They are having their individual situations evaluated to understand how proposed changes could specifically affect them. They are developing contingency plans and understanding their options. This is not the time to wait and see what happens. This is the time to be proactive and prepared. For those of you who are considering naturalization, my strong advice is to begin that process as soon as you are eligible. Citizenship provides the ultimate protection against changes to green card rules because once you are a citizen, these rules no longer apply to you. If you are currently eligible to apply for citizenship, do not delay. The naturalization process can take over a year in some cases, and you want to complete it before any new restrictions potentially take effect. If you are not yet eligible for citizenship but will become eligible before 2026, you should be gathering your documentation now. You should be studying for the citizenship test now. You should be preparing your application so that you can file it immediately upon becoming eligible. Every month counts when we are talking about potential changes that could dramatically alter the requirements. For green card holders who rely on travel outside the United States, you need to seriously evaluate your travel patterns. If the physical presence requirements become more stringent, you may need to make difficult decisions about how you spend your time. This could mean reducing visits to your home country, bringing family members to visit you in the United States instead, or restructuring business arrangements that currently require frequent travel. I also want to address the emotional weight of everything I have shared today. I know that hearing about these potential changes can be frightening and overwhelming. Many of you have built your entire lives in the United States. You have raised families here, built businesses here, and contributed to communities here. The thought that your status could be questioned or complicated is deeply unsettling. But I want you to understand something important. Being informed is the first step toward being protected. The green card holders who will be most affected by any changes are those who do not know changes are coming and therefore cannot prepare. By watching this video and taking this information seriously, you are already ahead of millions of others who have no idea these discussions are even happening. The United States has always had a complicated relationship with immigration policy. Laws and rules have changed many times throughout history, and they will continue to change. What remains constant is the need for immigrants to stay informed, stay prepared, and stay resilient. You have already demonstrated incredible resilience by navigating the complex process of obtaining a green card. That same resilience will carry you through whatever changes may come. I want to encourage you to share this information with other green card holders you know. Many people in your community, your workplace, and your family may be completely unaware of these proposed changes. By sharing what you have learned today, you could be helping them prepare for a future that could be very different from what they expected. Make sure you are subscribed to this channel because we will continue monitoring these proposed changes and will update you as soon as new information becomes available. The situation is evolving rapidly, and staying informed is crucial. Hit that notification bell so you never miss an important update that could affect your status. In the coming weeks and months, we will be providing detailed guidance on specific steps you can take to protect yourself. We will be covering naturalization strategies, documentation best practices, and analysis of new proposals as they emerge. This is information you cannot afford to miss. Remember, the most powerful thing you can do right now is prepare. Document your presence in the United States, organize your records, consult with professionals, and if you are eligible, begin the citizenship process immediately. Do not wait until changes are implemented to start thinking about how they affect you. By then, your options will be much more limited. Thank you for watching this important video. Your future in the United States is worth fighting for, and being informed is the first step in that fight. Please share this video with anyone who needs to hear this information. Together, we can make sure our community is prepared for whatever changes may come. Stay safe, stay informed, and stay prepared.